warahmatullahi wabarakatuh. So today I will make a coverage report on the case of Bosnia and Herzegovina against Serbia and Montenegro, where the states involved in this case is Bosnia and Herzegovina and Serbia and Montenegro. In this case, the plaintiffs are Bosnia and Herzegovina, whereas the defendants are Serbia and Montenegro. The issue in this case is whether Serbia and Montenegro has violated their obligations under the Convention on the Prevention and Punishment of the Crime of Genocide during the Bosnian War by committing, aiding and failing to prevent the acts of genocide in Bosnia and Herzegovina. So, what happened in this case? In this case, the Bosnian War was a war between Bosnia and Herzegovina and Serbia and Montenegro. During this war, Serbia and Montenegro has provided substantial military and political support to the forces of the Bosnian Serb, which was led by Radovan Karadzic and General Ratko Mladic. The forces that were carried out were of cleansing and ethnic and widespread violence. With this, it was seen that the massacre in Srebrenica was the most atrocious atrocity, as it involved the execution of the Bosnian boys and men, as well as the forced displacement of the children and women. Due to these atrocities, Bosnia and Herzegovina argued that Serbia and Montenegro were in compliance with this atrocious act and have failed to prevent and punish those committing the act of genocide, thus violating their obligations under the Genocide Convention.
Excuse me, miss. Do you mind if I ask you some questions?
Yes, of course.
Do you know about the case in regards to the Bosnian War?
Oh, the case that concerning the application of the Convention on the Prevention and Punishment of the Crime, right?
Yes, absolutely. As we know, the Republic of Bosnia and Herzegovina instituted proceedings in respect of a dispute concerning alleged violations of the Convention on the Prevention and Punishment of the Crime of Genocide. And a critical aspect of the case was the application of Article 8 on the International Law Commission's article on state responsibility for international wrongful acts, particularly regarding the meaning of direction and control. If you don't mind, may you share your opinion on or commentary regarding this issue?
First, the case between Bosnia and Herzegovina against Serbia and Montenegro is a landmark judgment by the ICJ, addressing state responsibility under international law. Today, more complex issues arise in determining whether conduct was carried out under the direction or control of a state. Referring to the Article 8 of RCWA, this article provides that a state is internationally responsible for wrongful acts committed by private persons or groups if those individuals or groups act on the instruction of or under the direction and control of the state. Here, Article 8 deals with two such circumstances. The first involves private person acting on the instruction of the state in carrying out the wrongful conduct. The second deals with a more general situation where private person act under the state direction and control.
See, meaning that such conduct will be attributable to the state only if it's directed or controlled the specific operation, am I right?
Yes, correct. And the conduct complained of was an integral part of that operation. For cases of this kind, most commonly, ICJ will look at the degree of control which must be exercised by the state for the conduct to be attributable. We can see one example in the Nicaragua case, with ICJ was analysed in terms of the notion of control. Then, it held that the US was responsible for the planning, direction and support given by US to Nicaraguan operative. But it rejected the broader claim of Nicaragua that all the conduct of the Contras was attributable to the United States by reason of its control over them. Thus, while the US was held responsible for its own support for the Contras, only in certain individual instances were the acts of the Contra themselves had attributable to it based on open actual participation of and direction given by that state.
Wow, such a brilliant explanation from Miss. Do you want to say anything for the outsiders?
Okay, as my last word, bear in mind that the important role played by the principle of effectiveness in international law, and it's necessary to take into account in both cases the existence of a real link between the person or group performing the act and the state operation.
Thank you so much for giving your time.
Welcome.
So in regards to the Bosnian War, what do you think of the test for attribution adopted by the court?
So, in regards to the Bosnian War, right? Okay, so for the test for attribution, I actually disagree with that test because it is, I'm sorry, but it's quite narrow-minded because like it's just for the short term. They just say whether or not that person actually has a direct approach. They give that specific instruction to do something, even though yes, the respondent. It was actually found that the respondent didn't give a direct specific instruction, but it still led to a very atrocious massacre. And with that, I think I would suggest that they actually follow the Tardik approach, which is the approach of actually having a broader approach, meaning that you have an overall test, meaning that we can see that whether or not, even though without a specific instruction, would that still have led to something else, meaning that in a long-term situation. And I think, does that actually answer your question?
Yes, thank you.
Welcome.
Mister, can I ask you some question? Yes, you can. In this case, do you find the court reasoning is persuasive, and can you explain why you say so?
Alright, so regarding that question, I have to give an answer. What is the meaning of the court reasoning is found to be persuasive? When a court reasoning is described as persuasive, it means that the reasoning is described as convincing or influential, but it is not binding on other courts. Courts may refer to the persuasive reasoning to support their decision, especially when faced with similar legal issue, but they are not obligated to follow it. Next, back to the question, why is the court judgment in this case, reasoning in this case, considered as persuasive? First, authoritativeness of the ICJ. The International Court of Justice (ICJ) is the principal judicial organ of United Nations, and its ruling carries significant weight in international law. The court interpretation of the Genocide Convention provides authoritative guidance on the obligation of states under international law. That's the first one. Second, thorough examination of evidence. The ICJ relied on extensive evidence, including findings from the International Criminal Tribunal for the former Yugoslavia (ICTY) to establish that genocide occurred in Srebrenica. The court applied a rigorous standard of proof to determine Serbia's responsibility, ensuring the credibility of its findings. Next, the clarification of state responsibility. The judgment in this case clarified the distinction between the state responsibility and individual criminal liability for genocide, addressing critical area of international law. It emphasized that the duty of states to prevent genocide and cooperate with international tribunal to set the legal precedent for the future cases happen in the future. Next, the consistency of international legal principles. The court applied well-established principles of international law, particularly those related to state responsibility and treaty obligation. It reinforced the principle that states have an obligation to prevent genocide even beyond their borders. So, to summarize, the 2007 ICJ decision is found to be persuasive in terms of legal reasoning and its influence on international jurisprudence. However, its limitation, particularly the standard of proof and the scope of result, may restrict its impact in some situations. The decision remains a cornerstone for comprehending state liability under the Genocide Convention, while its application may require significant clarification in the future cases.
So in regards to the Bosnian War, what are the implications for state accountability on adopting this test over other possibilities?
So, for the first implication is high threshold for state responsibility for non-state actors. In the Bosnia and Serbia case, it illustrated that the threshold for a state to be responsible for the wrongful acts of non-state actors, including armed groups, militants, is high, specifically for direction and control to be established under Article 8. The state must exercise a degree of command and authority over the specific action of those actors, not merely provide general support. The implication is that it creates a narrow space for holding states accountable in the cases where they assist or support non-state actors, even if those actors commit grave violations like genocide. It suggested that unless the state is directly controlling specific conduct of non-state actors, it cannot be held responsible under Article 8. The second implication is that the judgment set a high precedent that's for how it is difficult to establish state responsibility for a genocide when the state provides indirect support to perpetrators.
The court decision illustrates that providing logistical or military assistance does not necessarily mean that the state has enough control to be held responsible. This standard may make it harder to hold state accountable for genocide, particularly when the state is not directly involved in specific acts of violence but plays an indirect role, such as through training, funding, or supplying arms. It increases the burden of proof for victims to seek redress from states under international law.
Thank you for answering the question. So, Mr. Nabil, do you have any suggestion in regards to the Bosnian War case?
My suggestion is that the court could use the overall control test. The overall control test is one of the examples of more accommodating criteria that might be considered. This will enable the court to take into consideration the state overall influence or control over a non-state actor, even in the cases when the state is not directly involved in any particular wrongdoing. This more comprehensive strategy might guarantee more responsibility and take into account the intricate relations between the state and the non-state actor itself. That's all from me.
Based on the discussion that we have made in regards to the Bosnian War case, what can you conclude from this case?
Well, I could conclude from this case that the ICJ declared that although Serbia was not directly accountable for the genocide in Srebrenica, it was accountable for its failure to stop it. This ruling brought to light the shortcoming of the effective control test in determining the governmental accountability. The court used an effective control test and set a high threshold for attributing a state responsibility. This required direct evidence of control over the specific wrongful act by the non-state actor. The ICJ reliance on the effective control test highlight the difficulties in proving the state accountability, especially in the complex conflict situation where the non-state actor operates with varying degree of the state support. Despite the challenge in proving direct state responsibility, the ICJ held Serbia accountable for its failure to take all the necessary measures to prevent the genocide at the Srebrenica. This aspect of the ruling reinforced the principle that states have obligation to act proactively to prevent genocide and to ensure the accountability even if they do not have direct control over the perpetrator.